Informational hearing. The topic is the Federal Arbitration Act, the U.S. Supreme Court, and the impact of mandatory, or some would say forced arbitration on California consumers and employees. We'll go to the mandatory statement so that it allows us to hear from both sides, some of who think this is the greatest thing since canned tuna and some who think it's a terrible thing. And hopefully today we'll hear from both sides or the various numbers of sides on the issue so that we can get a better idea on how this form of resolution is impacting the people of our state. And I want to welcome everyone to our hearing. I want to introduce our new chief consultant for the Senate Judiciary Committee, Margie Estrada, to my right. Margie comes to us having worked most recently for the President Pro Tem, Kevin De Leon, as his assistant counsel on judiciary matters, so it really isn't too big a leap or fall, depending upon how you look at it, to join us. We're very excited about her being here with us and want to welcome her to our family of lawyers and others on who care deeply about issues affecting our judiciary and our judicial system. I want to thank those who are here. I know some of you traveled a far distance, perhaps coming as far as the East Coast, although I don't know whether we have to give you major kudos for that. It's cold there and warm here, so I suspect many of you are just as happy to be here as we are to have you. But we are delighted, and for those in the audience or listening at home who may not be as well-versed with arbitration, arbitration is a form of dispute resolution that allows for parties to resolve their disputes and grievances outside of the traditional court system. And when we talk about mandatory arbitration or mandatory arbitration clauses, we're talking about a clause in what they call take it or leave it boilerplate contract that requires the party, frequently with weaker or no bargaining power, to agree to resolve some or all of their disputes by way of arbitration instead of in the courts. Now, there are some arbitration clauses that exist in the business relationship between equals, and where the agreement is one that is negotiated. That's really not the focus of our hearing today. Our hearing is going to be in circumstances where they really are viewed as take it or leave it situations. And if you don't like the binding mandatory arbitration provision, then you cannot enter into an agreement to either get services or do business with the person or the entity that is requiring signature and sign off on the arbitration process. So, as such, this is a very important issue for all Californians. For some, it's sort of esoteric. You get a 20-page contract and you're asked to please sign here, and you say, what is it? And you're frequently told, oh, it's just standard language. I'm always very wary of just this as a standard form. Standard by whose definition? And a lot of people just sign them, that they don't think twice about them. They don't recognize that they are, in many instances, signing away some very significant, some would argue, constitutional rights. But it's not only important for consumers, but also for employees. We are seeing a number of these mandatory contracts in the employment arena, so it's also critically important for employees and for employers and businesses alike. When it comes to arbitration, there are many differing points of view as to whether both sides actually benefit from resolving their disputes outside of the court process, given a lot of the delays as a result of budget cuts and so forth, the amount of time it takes frequently to litigate one's grievance. The arbitration process can be much speedier and more efficient. But then the question is it more fair and just, or is it as fair and just as if the process were through the courts? And the differing viewpoints that we have tend to even get stronger as when we talk about this mandatory process versus voluntary arbitration agreements. And frequently those are done, as I mentioned earlier, in a business context between equals with equal bargaining power, who recognize that indeed going through the arbitration process can be most beneficial, but they make that choice, and that's hence the term voluntary as compared to mandatory. Again, bringing resolution to disputes in a less formal setting can be a big plus, especially with the courts as underfunded and overburdened as they are. But we also need to make sure that the use or overuse of these mandatory arbitration agreements don't end up creating a privatized system by which important statutory and constitutional rights are rendered meaningless. And I think that is, for many of us here in the dais, a major concern. You know, part of what makes us so proud of living in a democracy and our American form of justice is the notion that justice, when you see the scales of justice being held, justice is blind. So it is not a question of who has the most money, who has the most power, but justice is supposed to be fair for us all. Again, we also have to, and this is one phase of our discussion, we have to recognize that California cannot operate in a vacuum on this issue, and that the United States Supreme Court has spoken fairly loudly and regularly and recently on the whole issue of arbitration, and has made it abundantly clear that as a matter of federal law, arbitration agreements are enforceable and must be enforced by their terms, regardless of whether they're the product of a voluntary or mandatory agreement. And so to that end, we hope in our hearing today we will provide a firmer understanding of exactly what lines the Supreme Court has drawn around the ability of states to act when it comes to addressing some of the issues that may arise in mandatory arbitration, binding arbitration agreements. So part of our hope here is, rather than reinvent the wheel, that we really can find areas where California does have the flexibility to potentially take steps to ensure that the system operates as fairly as possible for all parties. And we hope to get a better understanding of how these mandatory arbitration clauses are actually being used in California, and would like to know how prevalent they are. So hopefully the speakers today will be able to deal and address with those issues. We're also going to take a closer look at the ethical rules that we have created and promulgated in California to address the neutrality of arbitrators. I know when I was in the Assembly back in the early 2000s, we did some legislation on this. There was some real concern about the ethics of these so-called neutrals, who are, by virtue of some of these agreements, subject to absolutely no oversight, to no appeal, don't even have to provide a record or a basis for their opinions, how critically it is and important it is that our judicial process, whether it's a formal or informal one, does serve justice in our state. So we're going to examine how those rules and how the steps taken by providers of arbitration services can ensure fairness and protect the integrity of the arbitration process. And hopefully, with the experts we have today, they will be able to suggest ways that we can improve the arbitration system from contract to resolution. And with that, unless anyone else has any comments to make preliminarily, we have a wonderful set of panelists, and if we can go ahead and proceed, that would be great too. But I would like to offer, if anyone has a word or two that they would like to share. No? All right, then let's get started with our first panel, which will be an overview of the federal and California arbitration acts and federal preemption issues. We have Paul Dubois with the California Dispute Resolution Council. We have Carla Gilbride, Cartwright Barron Staff Attorney, Public Justice, and Robert Olson, who is a partner with, is it Graines? Graines, Martin Stein, and Richland, here to talk with us today. Thank you, ladies and gentlemen, for participating. And if we can start with Mr. DeBow. Good afternoon, folks. Thank you very much for being here. Much appreciated.
Thank you for inviting me. My name is Paul DeBow.
Would you move the mic? There are people perhaps listening at home or in their
Okay.
offices, and we want them to be able to hear.
How's that?
Perfect.
My name is Paul DeBow, and I'm here on behalf of the California Dispute Resolution Council, known as CDRC. I'm the legislative chair of the CDRC. We're a nonprofit membership organization that was formed in 1994 to advocate for fair, accessible, and effective ADR processes. And our membership consists of several hundred individual ADR neutrals, together with the community dispute resolution organizations and providers of ADR services, and we represent more than 15,000 mediators and arbitrators in California. I have been a full-time neutral doing both arbitration and mediation since 2001, and I did it part-time before that when I was a litigator. And I was an advocate at that time as well in arbitrations. I estimate that I have taken part as an advocate or arbitrator in about 200 arbitrations, and I'm a member of the AAA employment panel where I do most of my arbitrations, although I do some AAA securities and commercial work. Consumer arbitration really developed around the 70s, I believe, and as the chair has pointed out, most of the contracts are mandatory. The consumer or the employee, and by the way, when I use the word consumer arbitration, I'm referring to employees as well. And they were mandatory contracts, and when we first saw them, they were favorable to the vendor or the employer. They had terms that favored those people. There usually was no mutuality. In essence, they were procedurally and substantively unconscionable. But unconscionability is a defense to a contract, and over time, our courts in California have done a very good job in refusing to enforce these unconscionable contracts. And casting aside the issue of class action waiver, most of the arbitrations that occur today, in fact, it's a rarity where an arbitrator hears a contract or takes part in an arbitration that the contract's unconscionable. In fact, JAMS and AAA will not even take, if they can see that the contract's unconscionable, they probably will not administer the arbitration. My task here today is to tell you or describe what happens in an arbitration where we have a fair contract, which is almost all the cases now. And at the end, I'll briefly describe what I see as two major problems in consumer arbitration, two with the mandatory arbitration contract and the class action waiver. An arbitration begins with the filing of a demand, and it's accompanied by a fee, but both AAA and JAMS have provisions that the fee cannot exceed the same fee that will appear in court. In other words, it's not more than $250. And in fact, at JAMS, in an employment contract, a mandatory employment contract, there's no fee charged to the employee. In addition, the AAA will reduce their fee if the plaintiff is indigent. All the other fees, including the arbitrator's fees, are paid by the vendor or the employee. And in addition, the AAA and JAMS will not administer a contract that has a prevailing party clause. That is, if the consumer or employee loses, he or she will not pay the other side's attorney fees. It's also a statute, 1284.3, that only pertains to consumer arbitration, not employment arbitration, that also prohibits the prevailing party contract to be enforced. The AAA operates under the Consumer Due Process Protocol. JAMS has their own protocol. Those two protocols ensure that the trial be fairness. They're part of the rules, so they have to be conducted in a fair manner. In addition, the AAA follows the ABA Code of Ethics for Arbitrators. As I understand it, I'm not a JAMS arbitrator, but as I understand it, JAMS has their own set of ethics. And basically—
We'll be here to talk about them later, so thank you.
All right, I'll pass that up. All right. The opponent files an answer. The opponent can't file a demurrer under the rules. So therefore, there's no big pleading games, and that makes it cheaper for the employee or the consumer. The next step is to pick the arbitrator. And the arbitrator is selected from a panel, and the parties have the right to look at the entire panel of the provider and pick from that panel. And eventually, and hopefully they will agree. If they don't agree, then the provider is obliged to pick somebody. Once an arbitrator is picked, that arbitrator must make disclosures. And the Code of Civil Procedure, as the chair pointed out, requires certain disclosures to be made. It's statutorily imposed, Section 1281.9 of the Code of Civil Procedure. And there's a few, I'll just mention a few of them that you must disclose, one of which the arbitrator must disclose any other arbitrations or mediations that he or she conducted with a party or a lawyer for a party in that arbitration. And he or she, the arbitrator, must disclose the outcome of that arbitration. With the mediation, you just say it's settled because it's confidential, or it didn't settle. You must disclose any relationships that you have with a party or the lawyer. And when I say lawyer, the lawyer includes the arbitrator's law firm having a relationship and the lawyer's law firm having a relationship. It's not just the arbitrator himself or herself or the lawyer in the arbitration himself or herself. Once the disclosures are made, under the statute, the parties have 15 days to challenge the arbitrator. If they challenge the arbitrator in the time period, the arbitrator must be removed. The provider has no discretion. The arbitrator is out and another arbitrator has to be chosen. And as a side point, if the arbitrator doesn't reveal the proper disclosures, that's ground for vacatur. The arbitrator also has a continuing obligation to disclose. So if something happens that he or she discovers along the way that they forgot to mention, whatever the case may be, and it comes up in the middle of the arbitration, the arbitrator is obliged to make that disclosure. The 15-day period runs again. The only difference is this time, under the statute, the provider can decide whether the challenge is valid. But again, if the provider errs and in hindsight that arbitrator should have been challenged, that is ground for a vacatur. There's another provision in the disclosure rules about taking future business from a party or a lawyer in the arbitration. The arbitrator has two choices. He or she can say, I will not take any cases while this arbitration is pending. And if the arbitrator signs that part of the disclosure, then that arbitrator cannot take any future assignments from a party or a lawyer in the arbitration. However, if the arbitrator says that he or she will take future cases, then the parties can challenge the arbitrator on that ground. But if they don't challenge that, the arbitrator proceeds and is offered a future case, the arbitrator must notify the parties in the arbitration. But the parties in the arbitration at that point can only see that, and they know that, they can't do anything about it. However, if they lose the case and they believe that the arbitrator was biased because of the second case, they can raise that in a motion to vacate, and a court will decide whether, in fact, the challenge is valid.
Inquirer, apologize for interrupting. Do you know how many instances where challenges have been made, have been affirmed by the courts? Is there any documentation on the number of times these arbitrators are challenged? We don't have any of that data.
You know, I do know, in my case, because it's my business, I always say I'll take future cases. And it hasn't happened too often where I've done it. And but in those cases where I've done it and I've tried the case and where I've held for the consumer or the employee, I do mostly employment arbitration. When I fell for the employee, I haven't heard of much of being challenged afterwards. So at least in my case, I'm not aware of anybody getting a reversal on a decision I made. So.
Would they have to notify you, though, that they were?
No, but you'll find out. That's,
Point of information as well, and appreciate the presentation, but on these disclosures in arbitration, we passed a law, bill I carried in the Assembly. Those disclosures cannot be waived. There had been a practice of parties to arbitration saying we'll waive disclosures. So a corporate representative and an arbitrator may be fine waiving it. An unrepresented employee who doesn't know the practice would sign the waiver thinking this is a standard practice. No longer can those disclosures be waived by the parties.
Thank you.
and
I'm sorry.
so you never see that anymore. That's true. In the old days, once in a while you saw that. Though I always made my disclosures anyhow, I ignored it. But that was my case. I want to mention there are two misconceptions about arbitrators and arbitrations, and one is I hear the claim that arbitrators favor the repeat player, and that's not correct. And the reason it's not correct are counted disclosures. The fact is that members of the plaintiff's bar and the defense bar, they all keep tabs on arbitrators that with their fellow attorneys. So you're pretty well known whether what you've done in the past. An arbitrator who consistently rules in favor of the corporate party will soon have no business. You can't, so it's well known what you do. Secondly, there's always Google. In fact, one can say that a lawyer who does not Google the arbitrator has committed malpractice. So basically, the parties know a lot about the arbitrators whose names come before them that they have to select. In fact, if there is a repeat player in arbitration, that repeat player are the lawyers. They're the ones who continually come before you. Like in my cases, I mean, there's an employment bar, and I know many of the members of the employment bar, and there's a defense bar, and they all know what's going on. So that's a protection for the employee in my situation. The second misconception you hear is that because technically arbitrators don't have to follow the law, it's a wild west game and you never know what can happen, the arbitrators can just come off the wall with a decision. And I suppose an arbitrator could do that, but again, if an arbitrator did that on a regular basis, he or she will not have business. In fact, almost all the arbitrators that I know are professional people, and I do this and they do this, and that is, we pretty much follow the law and the rules of evidence of the arbitration. It may be fuzzed a little bit, but the parties still don't object to it. And we write reasoned decisions and we cite cases. So 99% of the time, you're going to get a decision that's reasoned with case law. Now, the loser may not agree with you. That happens in court. But the fact is, it's not a Wild West game at all. And the idea that arbitrators just do anything they so please is not quite correct. Once the case is over, the arbitrator, it's basically a lack of appeal, as the chair has pointed out. But you can vacate an arbitration award. And in California, there are 6 grounds: corruption, fraud, or undue means, arbitrator corruption, arbitrator bias and misconduct, exceeding the powers, failure to postpone a hearing after sufficient cause or failure to hear material evidence, and failure to make the disclosures. But in addition, in the document I saw that the committee put out, that under the Montarch case, errors of law cannot be appealed, and that is correct. But there is an exception to that under case law in California, and the exception is that an error of law by an arbitrator can lead to a vacatur if the error renders the award incompatible with California public policy or violates the statutory rights of the consumer or the employee.
If you'd wrap up, I apologize. We took a little of your time, so I'm giving you a little more, but if you could.
I appreciate that. I just want to talk about, the two class action waiver and mandatory arbitration. The class action waiver, I totally disagree with the deception decision. It's unfortunate we have that, but the problem is we're stuck with it unless Congress does something, because under the Supreme Court decision, it's preempted, and it's unfortunate, it's ridiculous, but that's all I have to say. I don't like it. The second thing is mandatory arbitration. Again, the CDRC opposes mandatory arbitration as it currently exists, but be careful. To get rid of the problem we have now under mandatory arbitration is the consumer or employee has no choice. If you get rid of it completely, the consumer or employee still will have no choice, and here's why. Or you can, most of the cases are around $150,000 value, the majority of cases. A lot of those cases will not be taken by an attorney in court. And so if you have, let's say, a $100,000 case, a $120,000 case, and there's no arbitration contract, mandatory arbitration is eliminated, you go to the corporation, you say, I want to arbitrate this dispute. And the corporation that used to love arbitration now says, we're not going to arbitrate, knowing full well that the employee or consumer has no remedy. So I think what should be done is permit mandatory arbitration, but only permit mandatory contracts that have an opt-out provision. So in the case of the consumer can opt out. With the employment's case, the employee is a little more complicated. The employee can opt out, but you should have to give him a period of time to opt out so that he can think about it. And secondly, the opt-out provision has to be plain, in plain sight rather, and it has to be fair. It has to, there's no penalty for opting out. So if you're an employee and you opt out, it doesn't affect your job, et cetera, et cetera. So I would recommend that we have, if we ever been able to change the law, retain the mandatory contracts, but have the opt-out provision. When we do that, then it's the employee and consumer who has the choice, not the corporation or the employer. Thank you.
Thank you very much. Very helpful information and suggestions. Next, Carla Gilbride. Welcome, and we're going to give you about 15 minutes, and hopefully, I apologize for interruptions, but for clarification, sometimes this stuff can get a little esoteric, and I want to make sure everyone here on the dais and those in the audience and listening are able to stay awake and follow what we're doing. So thank you. Thank you, sir.